case. But if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to the court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than $50,000, Judge. I believe that $25,000 would be appropriate. You know, I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice is to set a high bond, which in all honesty is, you know, enriching the bonding company, but I don't think that that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bond?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do that.
And that's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March, and so I think there was one that was a
May. It's May.
I'm sorry, there was a delayed outcry.
That could be.
Yeah.
But the incident date was May
23rd or something like that.
May 3rd, and then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank
you.
you.
Ms. Clark. Oh, Ms. Clark, before you go, you will come on up to the podium. Good morning. Yes, Ms. Jackson, how are you doing?
Oh, I'm great. How are you doing?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it.
Great, if you'd share that, please.
He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction in 2022 in Cobb County for a non-RICO penal offense. Nothing in addition, Your Honor.
Thank you so much. Officer Evans, I wasn't going to be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation at Cobb in light of this situation? I can't hear you. It's odd. You're not muted, but I can't hear you. Other people can hear you. That's
morning, Your Honor.
Good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had, in speaking communication with the defendant, he was trying to give himself an opportunity to turn himself in. And after a few months, the defendant did not turn himself in, so that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So
Now,
that
Mr.
is-
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that, that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Ayala factors. Your Honor, the state wants to bring the first reason we feel that the defendant risk of flight. It seems that based on counsel opposite's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that that is likely because of this arrest. There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is. There is a young lady, Kim Yee, who actually was a friend of the victim's at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other, and there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life, and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime does warrant a no bond status. And that's what the state is asking for. We believe it's appropriate in this case because the defendant is currently on probation. He has shown that he does not comply with court rules as he has violated bond orders when he was actually on probation. And as I said, he's on probation for the drug marijuana with intent to distribute and the firearm charge out of Cobb County. I think that he has a high risk of intimidating witnesses because of the fact that there is a friendship between the female that was assaulted. I think the roommate or something was also, he knows the defendant. So there are a lot of people that the defendant would have access to And so for those reasons, I think the bond should be denied.
All right, thank you, Ms. Clark. So, Mr. Tedis, you had asked to have rebuttal time. You certainly can have that. I asked you to include in there what more you can add, as I believe it was your client's father was sort of raising his hand on this issue of the delayed turn-in.
Yes.
It's getting more mysterious to me. And it's not dispositive here.
Sure.
I think the Cobb situation is for a temporary ruling that I'm going to make. But if you could clear up as best you're able, knowing that you're parachuting in as well,
Sure.
what your understanding is with, hey, you should turn yourself in, I'm not turning myself in, however that played out.
Sure. My understanding is that the police were talking with Mr. Baker Robinson. They wanted him to come in, as I said before, make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple months were, Mr. Wolf was talking to police about arranging a turn-in at the jail, which they did, and they surrendered him.
So ultimately, there may well have been before, I'll call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows, there may have been some back and forth, and,
Sure.
and the police may have perceived that your client was reluctant.
Right.
It's not like he's under an obligation, but
Of
he
course.
was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever.
Correct. He was surrendered to Fulton County Jail.
Got it. And the state's perspective is, gosh, that took a whole lot longer than it should have if this is someone who was coming in to say, hey, let's clear this up.
Sure.
And I understand it, and that's a reasonable perspective. Anything else you wanted to add?
Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript, interestingly that the state brought up, hey, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a dangerous community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, U.S. Constitution. That's just not the case. Ayala is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not dispositive. With respect to he knows people so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing contra to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, there are various flavors of what this charge could be. Georgia has no degrees. Something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified, were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend it is not. And so far, he's still continuing to be incarcerated on a case that he's presumed innocent, and which we don't believe is a factually strong case for the state. So because of all of those things, we would ask that, again, the bond not exceed $50,000. We don't care if he's confined to an ankle monitor or even home confinement except for work, but he should not continue to be held in custody with no bond, given the light of he meets all the statutory factors, and again, the strength of the state's case at a fully drawn-out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize. I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for the marijuana and gun case. I want to get you there so that can be addressed. Should that be addressed, and the only thing left holding you in custody is this no bond situation, we'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. So I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that? Okay. Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. Is it just be some kind of transport order? Because he'll have to be released from this hold to get to Cobb.
Right. We'll work with Cobb on that so that then there's a hold put back in place. But this, we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address this. Okay.
Very well.
Ms. Clark, anything else?
No, Your Honor.
All right, thank you. Do we have an update?
Yes, Your Honor, update on the defendant cases for this morning. I have been able to get in contact with the other two attorneys who should be here for their clients. That's Mr. Pizzoli. He's
Okay.
presently in 2B with Judge Brooks doing preliminary hearings, but said he'll be up here as soon as he gets a free moment.
Okay, so he does want to go forward on his cases.
My understanding is that Mr. Pizzoli said he is ready for Hutchison, McCaslin, and Drinkard.
Caslin, now Drinkard, Drinkard. Okay, great.
And
Does he have a client where he's saying, sort of like your client, we're not doing it today?
Yes, that would be for Mighton as well as Alvin Powell, position 5.
Okay, so Reuben Mighton, we will defer to another day. And you said Alvin Powell, number 5?
Yes, Your Honor, same announcement.
Defer, got it.
And
And then you said there was a third attorney.
yes, one more. Jessica Jones, Attorney Jones, has Daryl Williams as position 1. She also indicated she's not ready, but she would try to.
There's a young lady back there who says she represents Daryl Williams. That was the name I still didn't get it. She was way in the back.
Okay, if Mr. Williams hired prior, then.
Okay, and did Ms. Jones have anyone else, or that was it?
That was it.
So Hutchison is Cazzoli, and he'll be here. Kukendall, we don't know. McCaslin is Cazzoli, and he'll be here. Alvin Powell, we're deferring. Drinkard is Cazzoli, and he'll be here. Mighton, we've taken care of. You're Roderick Powell. And then we don't know about Beatty, but that may also be the young lady.
Beatty, yes, I know that Beatty has hired private counsel. I don't know if that attorney is here.
Okay.
And Kuykendall is a co-defendant of McCaslin, so she would need
A conflict
a
defendant.
conflict attorney who I don't know if they got notice of this calendar or
Yeah.
anything like that.
Maybe not. So I'll at least let Ms. Kuykendall know we're not ignoring bond. We just, ma'am, are you ready to go on Darrell Williams?
Yes.
And did you say you also have Mr. Beatty?
No.
No, just, oh, you had Carl Washington. Got it. So you've been retained by Mr. Williams or his family?
I am doing this hearing pro bono.
Okay.
I filed a limited entry appearance for the purposes of the bond hearing.
Just for bond? Okay, got it. Thank you. What do you want to do? We still don't have Kendrick. He's not up yet. Okay, so if we got Williams, why don't we knock that out? And then do we have, who else do we have up? So McCaslin will be able to do, we'll be able to do both those, just the lawyer's not here, so we should leave them up. That's it? Okay, then why don't we bring Darrell Williams up, at least make progress. Number 5. Number 8. Number 9. Yeah, we don't do anything until something is out. We don't have to proactively do it. And then number 3 is a conflict of interest case. So, yeah, we can do that today. If she gets brought over, I'll let her know and then what the situation is. Co-defendant number 4 has Cazzoli, and Cazzoli will be here. He'll be here for this one. All right, Ms. Rivers, are you ready? Okay, this is 24 PI 008200, State versus Darrell Williams. Good morning, Mr. Williams.
How you doing?
I'm okay. I'm Judge McBurney. I don't think we've met before, but we are going to talk about bond in your case. That's all we're doing today, just bond. And as long as there are bond issues in your case before it's indicted, that'll be in front of me. Once it's indicted, it's going to be randomly assigned. Could be me, could be a different judge. We'll see what the state's doing with the indictment. I need your lawyer to announce her appearance so we get that on the record.
Stephanie, I'm here for the defendant.
And spell your name now that you're closer to a microphone.
Last name is Isello, I-A-S-I-E-L-L-O.
Isello, Ms. Isello, thank you for being here for purposes of bond. Mr. Abate, are you handling this?
Yes, Judge.
Okay. Mr. Williams, you're charged with murder. You were originally charged with aggravated assault, and Mr. Clark passed away, so that was upgraded to murder. And I'm going to hear from Ms. Isello why you should get a bond and in what amount. Then I'm going to hear from Mr. Abate about what the state thinks about bond. And let me pause for 1 minute. Ms. Clark, you were going to give me a victim impact statement, but when we have another hearing on Mr. Robinson Baker, make sure you do that. All right. So, Ms. Isello, when you're ready.
Would you like me to sit at the podium? Or?
I think it's easier for Ms. Rivers to hear you if you do that. Thank you.
Good morning, Your Honor. Thank you for the opportunity to present this bond argument on behalf of Mr. Darrell Eric Williams, a man who stands before this court accused of a serious charge, murder. While the charge is significant, Mr. Williams is presumed innocent, and the purpose of bond is not to punish but to ensure his appearance in court and protect the community. We respectfully submit that Mr. Williams is not a flight risk, is not a danger to the community, and is not a risk of committing new offenses or obstructing justice. Under Ayala, these 4 factors guide the court's decision on bond, and the facts of Mr. Williams' case support the granting of bond. In addition, I must bring the court's attention to Mr. Williams' significant and urgent medical concerns. Mr. Williams suffers from chronic kidney disease, is a kidney transplant recipient, is diabetic, and also suffers from neuropathy. These conditions require regular medical care, specialized medication, and monitoring that the Fulton County Jail is ill-equipped to provide. Denying him bond under these circumstances would expose him to substantial and unnecessary risk to his health. Lastly, it is critical for the court to know that Mr. Williams is the person who called 911 during the incident that led to his arrest. This act of seeking help does not align with the actions of someone trying to flee, evade, or obstruct justice. Due to a miscommunication with responding officers, Mr. Williams was charged. We are confident that as the facts unfold, the charges will be reconsidered, but in the meantime, we ask that the court grant him a bond so he can receive the medical care he urgently requires. The first Ayala factor asks whether Mr. Williams poses a risk of flight. The evidence clearly shows that he does not. Mr. Williams was the 911 caller and not a fleeing suspect. The most compelling evidence that Mr. Williams is not a flight risk is the fact that he is the person who called 911 and was not fleeing the scene, hiding, or attempting to avoid law enforcement. Instead, he actively sought help and remained present as officers arrived. As I stated, Mr. Williams' health condition makes it impossible for him to flee. He is a kidney transplant recipient and requires ongoing medical care, including strict medication schedules, metformin for his diabetes, and treatment for neuropathy. Any interruption to his medical regime could have catastrophic effects on his health. He has every reason to stay near his medical providers and avoid life-threatening risks of being on the run. Mr. Williams is deeply rooted in this community. He is the father of 4 children, 2 adult daughters, and 2 young boys. He volunteers with food distribution programs to give back to those who have less than him. His friends care for him so deeply that they reached out to me when they were unable to find him around Thanksgiving and subsequently located him on the inmate roster at the Fulton County Jail. I agreed to handle this hearing pro bono because I was moved by the love and concern of his friends who were desperate to help a man they described as thoughtful, generous, and kind. Mr. Williams has no history of failing to appear for court proceedings. He has shown compliance with all legal obligations and has no pattern of attempting to evade responsibility. The second Ayala factor asks whether Mr. Williams poses a danger to the community. Here, there's no credible evidence to support such a finding. Mr. Williams does not have a serious prior history of violence or any criminal history involving firearms or weapons. The court is not being asked to evaluate a person with a pattern of dangerous behavior. It's also worth noting that Mr. Williams is 61 years old and does not have a history of weapons charges. Mr. Williams' role as the person who called 911 is critical to this analysis. His actions show that he sought help, not harm. The fact that the charges rose from a miscommunication with responding officers should be carefully considered. If the court has concerns about community safety, Mr. Williams is willing to submit to restrictive bond conditions, including curfews or electronic monitoring and pretrial check-ins. As far as the third Ayala factor, risk of committing new offenses, Mr. Williams does not have a pattern of repeated offenses. His record shows that he has been a law-abiding member of the community. He does have a pending battery charge from July, but as that case unfolds, it will be clear that he was defending himself from attack. Mr. Williams' primary focus is his health. Managing kidney disease, diabetes, and neuropathy leaves little room for anything else. His medical condition creates a natural structure in his life that drastically reduces the likelihood of reoffending. If there's any doubt, like I said, he is willing to submit to restrictive bond conditions. And there's no indication that Mr. Williams would interfere with the administration of justice. He has no history of obstructing justice, tampering with witnesses, or evading legal obligations. And it bears repeating that he is the one who actively invited law enforcement to the scene and was not attempting to flee. And again, I would emphasize Mr. Williams' urgent and unique health needs, which the Fulton County Jail, frankly, does not have the capacity to address or provide the level of care that he requires. And therefore, I would suggest that denying bond in this case would prove to be life-threatening for Mr. Williams. We request a reasonable bond that is aligned with Mr. Williams' financial means. He is on a fixed income from disability and faces eviction soon based on the fact that he's been incarcerated for a month and has fallen behind on his rent during that time. I'd ask the court to consider a bond not to exceed $25,000. I recognize that the charge is very serious, but he does have very limited financial means, and we would be amenable to any restrictive conditions the court sees fit to impose. In conclusion, I would submit that the 4 Ayala factors weigh in favor of granting Mr. Williams a bond. He is not a flight risk. He is not a threat to the community. He has no risk of reoffending, and his medical needs create an urgent and compelling reason for his release. For these reasons, I respectfully ask that Mr. Williams be granted a bond. Thank you.
Well, one question, and then there may be follow-up
Sure.
from you after we hear from the state. Is it your understanding of the situation that Mr. Williams was on the outside allegedly shooting in, or he was on the inside allegedly shooting out? If you know anything about the situation.
So my understanding of the situation is that Mr. Williams was in his home and heard shots outside his house and called 911 from the inside of his residence.
Okay. All right. Thank you.
Good morning, Judge.
Good morning.
The state would respectfully request you deny defense counsel's motion for bond for several reasons. The first being that the defendant does have 3 prior felony convictions, making him an A and C recidivist, in the sense that if convicted after trial, he'd be facing a mandatory life without the possibility of parole sentence. Furthermore, the state would submit to the court that the defendant is a risk of flight due to the strength of the case, in that Mr. Williams is seen on the ring camera waving a gun around after he shoots it through the door at the victim, who was inside of his home, who was struck in the face and ultimately dies.
So that was what I was asking Ms. YSL about. Mr. Clark is the decedent.
Yes, Your Honor.
Mr. Clark is in his home, or he is in Mr. Williams' home?
Mr. Clark is in his home, and Mr.
Meaning
Williams,
Mr. Clark's home.
Mr. Clark's home, yes.
And what you say that the ring cam video would show is that Mr. Williams would be outside the door, not of Mr. Williams' home, but outside of Mr. Clark's home.
That is correct.
And shoots into Mr. Clark's home.
That is correct.
Okay.
And actually shoots through the door and strikes Mr. Clark on the left side of his head. Ultimately, police are called and medical attention is attempted, but about 20 days later, he does succumb to his injuries due to being shot in the head. So I would submit to the court that he is a threat or danger to the people in the community in it, as he shot Mr. Clark through his own door, unarmed at the time, and posing no threat to the defendant. Excuse me.
Ms. Aiello indicated that Mr. Williams was the one who called the police and that he stayed on scene. Is that your understanding of the facts?
He is one of 3 people who called the police. He is actually the 3rd individual who called the police. The first 2 described that Mr. Williams was outside of the doors of not only their apartments, because it's a 4-unit apartment building or home, and he was...
Is Mr. Williams one of the 4 occupants?
That is correct, Your Honor.
Okay. So he's around his own space, may not have been his door, but it wasn't that he lived across town and came to this place?
Correct.
Okay.
Outside of their doors, screaming threats at all parties who were around and living in the apartment building. So 2 individuals called, not 2 females, called 911 indicating that, and that they saw Mr. Williams outside their doors and the door of Mr. Clark waving the firearm, and then heard a single shot. Mr. Williams did then call 911 and was incoherent, I guess is the best way to put it. He was under the influence of something would be what the state would submit to the court, and he indicated that someone had just shot his brother, and I can clearly state to the court that Mr. Clark is not Mr. Williams' brother, and he did remain on scene. Upon the officers arriving, he did admit to shooting Mr. Clark through the door. So I can agree with defense counsel as it relates to that. So based on all the factors, Your Honor, and all the totality of the circumstances, the state would submit to the court that at this time Mr. Williams is not a good candidate for bond and should remain in the custody of Fulton County Jail.
Do you have any information, I don't know that they'd be reaching out to you, I'll be doing some outreach, about the jail's ability to tend to Mr. Williams' health needs?
I don't. I can obviously reach out to whoever needs to be reached out to. I neglected to inform the court as well the incident that occurred that defense counsel had referenced that Mr. Williams was out on bond for. It was an assault from July of this year. It was actually an assault on the same victim.
Mr. Clark?
Yes, and there are eyewitnesses who watched Mr. Williams out of nowhere begin to attack Mr. Clark as he sat on the porch and was defenseless at that point as well.
All right, thank you. Ms. Isela, I'll hear from you again. I forgot to ask Ms. Jackson from pretrial services about Mr. Williams' criminal history. It sounds like Ms. Jackson, Mr. Williams has some convictions. I'm curious how old they are. If they're from the 1990s or if they're from 2 years ago. What information do you have? Oh, we're having this issue.
They're all, majority of them from the late 1990s. The most recent one is from 2002, the terrorist strikes in DeKalb County.
Okay. Ms. Nelson or Ms. Hansberry, can you call IT so we can figure out why we're not able to hear folks who have dialed in? It sounds like it's not just a probation issue. I mean, there's clearly something going on in the courtroom, but we weren't able to hear Ms. Jackson. Thank you. Ms. Iacella, I would like, with your client's permission, to be able to talk with the jail medical staff. They'll be more candid with me if Mr. Williams says, hey, you can talk to Judge McBurney about this. Yeah, but that's me. I don't, this seems different, but because it's clear, like we see a little microphone is showing that it's receiving things, but it's not coming out of the podium. But you may be right. Oh, those aren't working either? Okay, so this is swing by. Thank you. So,
Mr. Williams is fine with you contacting me.
okay, and Mr. Williams, I'm not trying to pry into your personal medical situation, but it's important that you get the care you need regardless of these charges. And I need to balance whether that can happen while you're in custody or if you need to be out on bond for that. So that's helpful, and I will reach out to the doctor who manages the health care at the jail. Was there anything, Ms. Isel, you wanted to add or respond to?
Your Honor, I have not had the opportunity to review the room footage, so I can't speak to the accuracy of the of counsel's characterization of that. But you know, I would submit that Mr. Williams was obviously in his home. He did not flee the scene. He is committed to fighting these charges and clearing his name, and I do believe he is a good candidate for bond.
Okay. Your entry is for bond. Is it as long as we're going back and forth about
Yes.
bond, or it was for today?
It's as long as we're going back.
Okay, all right. Mr. Williams, I'm not going to set a bond at this point. I need to talk with the doctor at the jail to better understand how the jail might be able to or might not be able to support your health needs. In the interim, I guess, I'm fine requiring the state to get the ring camera footage to you, even though you won't necessarily be the lawyer long-term. It's certainly helpful. They're not obligated to do that, but I often ask when the state is particularly reliant on something in a bond hearing to get that to the other side.
I would appreciate that, Your Honor.
Okay, great. Mr. Abate, would you be able to get to Ms. Iasello the ring? Oh, he's gone. Mr. Rao, would you be able to get the ring camera footage? I don't mean right now, but just in the next few days, get that across to Ms. Iasello.
Absolutely.
Is he coming back?
You should be.
Okay. Did he have to go down to 1C?
I believe so.
Okay. It's that kind of day.
Yep.
So, do you have any questions about what I said, Mr. Williams? What's your question, sir?
I see, if who got jail, they don't, they're not gonna, I mean, I already know that, because, other day I was telling them about my kidneys, okay, she was saying that, the diabetes thing showed that, my kidneys are good, but I'm thinking, I've been at a transplant, okay? All right, my brother gave me a kidney, and, they mean that, they just don't do enough for people, you know what I mean? They just don't do enough jail for people like that.
Okay, well, that's what I'm gonna talk to them about. And, are you on dialysis, or because you have a new kidney, you're not on dialysis?
See, I go back and forth, I had surgery in Tennessee, I had to go back for every 3 months.
Okay.
To be put on, what they call it, extra dollars, okay? Like, you know, I don't be on there like, you go out, I got be on there like overnight.
Okay.
Out, you know, yeah.
Well, I'll talk with the doctor, and then I will certainly let your lawyer and the prosecutor know, okay?
Appreciate it.
You're welcome. One time. With the referee. All right, so do we need to take a break so you can move people up and down, or do we have other people up? Okay, we'll do that. Mr. Rao, are you handling this, or do we need Mr. Abate back? No. You're in, okay. Let's get one thing up here on the screen. All right. Ms. Rivers, are you ready? Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick.
Hey, how you doing?
I'm all right. How are you doing?
I can't find you.
I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me, in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only, or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases, and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me. So when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering a bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're going to get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom?
No, he was in trial, but the co-defendants were.
Oh, okay, so there was a prelim not as to him personally and directly because he was in 1C.
Yes, Judge.
But in 2B, 1 floor up, they went forward with some or most of the other defendants.
Yes, Judge. And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are going to work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. I know some of those are strange questions because he's been in for 2.5 years, so it's not like there's a job at this firm where he was working for, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place, and that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so, while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. So that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street. You'll be staying with this person. But those people need to not be people with whom he associated before. Not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety. You're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them, and it's a great music making place, and the next day there's a dead guy in the parking lot. And that has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about what's that going to look like structurally, so that I know what I can put in the bond that's not sealed. Because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi? Okay, yeah, it didn't work again. It's not on your end. It's something happening in here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that.
I do.
It's a lot of co-defendants, and I'm wondering if you are able, at this juncture, to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's, co-defendant Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but
right,
that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
Okay.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you...
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms. Hanson.
Yes, Your Honor.
All right. Somehow that device's volume got turned down. We'll go back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. But they were able to secure a statement from Mr. Kendrick. And Mr.
Kendrick or from Mr. Wimberly?
Both, but
Okay.
with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery, and I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017, and I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then, on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by a convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116, and it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentence with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against, and I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office, so I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we will be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick were to go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation at a bond hearing or at a sentencing hearing.
That's
correct. Your best forecast with maybe one exception.
That's correct.
Okay. All right.
Thank you, Judge.
Thank you. Ms. Bumpus, I want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. Certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And, well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case, so they're not 2 separate crimes.
Got it.
2015 is the federal case.
All right, so there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge, so not two separate acts.
Okay.
And in me saying that, I don't know if this brings any, or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release, that's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation, hey, you report to those federal
Yes.
folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimber. And you know that's how it flows. And so if that warrant is out there, then we need to work through that. And setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted, or it's dismissed, or I know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way, and then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff, and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back, saying, all right, this time it was a cell phone, this time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay? Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case, don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured, so I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these two cases.
And Your Honor, how am I gonna, can someone email me about the probation?
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state?
No, Your Honor.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you need it.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am, thank you for being here. All right, we're gonna just figure out what I just need to know what is where. Yes. Excellent. Thank you, gentlemen. Maybe we can. She is. Okay. Do you want to? Would it be helpful that the Miss Kuykendall we can't handle today, but I could tell her that, and then you guys can take her down, assuming that's complicated to have her up here. Okay. Why don't you just bring her right to the door?
that was something that I considered fighting, and obviously in consultation with my client, we had those discussions. But I think for the time being, it's my belief that that is what's best. Sometimes a change of scenery is important, and we're hopeful that a change of scenery and the continued support of so many people will lead to a happy ending to this story.
Do you know what state he plans to live in?
I'm not going to share that information.
Did the Alfred plea play a factor into accepting the plea in the negotiations? If that wasn't on the table, would you have been amenable to another plea where he still would have been free, but not?
Well, the no contest to the gang act charges was important to us. We just sat through a trial for the last couple years where we've been bemoaning the fact that people have pled guilty to gang act charges when there was no indication that whatever was done was in furtherance of any gang. So I didn't want to turn around and do the same thing. So it was important that was accepted as a no contest plea. Certainly in a situation like this, and I thought ADA Sperry said it well in court, time was of the essence. There was really no reason for Shannon to continue to sit at 901 Rice Street to wait for the lawyers to figure it out. So we were appreciative of the state for agreeing to that resolution and that no contest plea.
We had to talk between courtrooms, obviously, to get their heads.
Right.
Ms. Bumpus, can you talk about the conclusion, well, not really the conclusion, but what the judge decided or not decided for your part?
Well, as you know, Judge McBurney made a decision to defer in making a decision based off of a potential probation warrant. I don't think the state knew about it or the judge knew about it, and I definitely did not know about it. So it was something that was a surprise to all of us and something that is still being confirmed.
Oh, so you didn't know going in there was a warrant, because you would have been obviously prepared for that.
Judge McBurney said from the bench that he was told from probation about the warrant. The state did not know about the warrant. Well, it's my understanding they did not, and the judge did not know about the warrant either.
So what is that like? What do you do next? You just got to sort that out.
Quickly going back to Mr. Jackson, how long has he been in jail now? Is it since the beginning of 2022?
Since March 17th of 2022, he's been in jail continuously.
What's the total, I guess the amount of probation is?
So from the case that we just tried, we did not challenge the possession of a firearm from March 17th. So the jury found guilt on that one count. He was sentenced to 10 years to serve 3, commuted to the time he served. So he had 7 years of probation going into today already. The sentence is 15 to serve 3, commuted to time served, balance probated concurrent with that. So essentially today he's gone from 7 years of probation to 12 years of probation.
So given all the cases, basically it's 12 years of probation
Yes.
that he's now dealing with.
Correct.
Added 5 more to the previous 7
No, it's concurrent. Concurrent. 12 total.
On the other plea they took with Judge Whitaker.
He has 7 years probation, and now this is 12 years, but it's running concurrent. Yeah.
I know there's attorney-client privilege, but in general, are you able to just share? You were pretty reflective in there, talking about how he's grown up, he's learned a lot, he has 4 kids. Either one of you can talk about just kind of what his mindset is as post this chapter.
The thing about Shannon that I love about Shannon is he cares deeply about people, and I think that this whole process, and probably certainly at the age he is now, where he's more reflective, he's realized how much certain people mean to him in his life. And it's just a matter of, we talk often, and I'm not going to share too much, but, we talk about life, and I think he's beginning to realize what's really important in life, and I've encouraged all those people also to make sure they continue to be there for him. And he just, sometimes I think we get so used to trying to survive on our own, and we forget that there's people there to support us. And sometimes we need to lean on those people. And that's what I'm hoping he will do, because I know there are many good people that are going to be there for him.
When do you expect him to obviously touch the grass?
So we've already been in contact with the sheriff department. The paperwork needs to go to the clerk of court. Then the clerk of court needs to fax it to 901 Rice Street, and they need to look it over. But I'm anticipating he would be released later on today. And if he's not, then when I wake up tomorrow, that's going to be first on my agenda, is to figure out what's going on.
Is anyone from his family wanting to talk or share their thoughts on his release now?
I don't think so. I think everyone's just appreciative, and but I don't think anyone wants to go public to make any statements at this time.
Mr. Kokomo, how you feel today? Oh, very good.
No, I just hope that we can keep fighting and pressing for Mr. Kendrick so we can get him out sooner than later.
And Ms. Pompous, are you also one of Mr. Jackson's attorneys?
I'm a halfway co-counsel.
She is.
Okay,
She's
I
being
just
modest.
wanted to make sure I wasn't, yeah.
She's co-counsel. Yes.
Does
Good.
he prefer, haven't been covering the whole thing. Does he prefer Mr. Jackson or Mr. Stillwell, or what should we?
So he prefers Jackson.
Okay.
He was listed as Stillwell in the indictment.
Right.
For the trial, and I just got so used to referring to him as Mr. Stillwell because I just thought it would be easier for the jurors to keep track of one name. But he does prefer Mr. Jackson.
Is it, because I guess we've referred to him as Mr. Stillwell in the other case.
Right.
Would we say Mr. Jackson, also known as Mr.
Yeah, that would be fun.
I like Jackson too. So, did he tell you when his first meal was going to, when he'd like his first meal to be? I heard rumors of menu floating around. Do you want to know what his first meal was going to be?
I told him I got him at Five Guys.
Oh,
I'm simple, man. So nah, he'll be all right.